Anthony. Did you get through it all?
Yeah.
Nice.
I mean, the white one is mostly just the same as the.
I got through the white one and I'm on just this hall.
If you know the white one, then you know most of the technical stuff.
I missed a lot.
You didn't go through that book?
I did. I went through page 93.
Oh, that's the more important book.
Okay, you do the whole first set. Let's look at the last one. That way it's fun.
Hey, Will.
Hey, what's going on?
How you doing?
Excellent. How are you?
Good. Yes. This chair is too low. Alright. Why are there two signed shoes?
Good question.
We want to make sure we're here.
Kind of curious, but.
Is there a... Hey, how are you, driver? Good. Nice to see you.
I was
Good.
watching
Oh.
Good to see you.
from my arm.
You're back and...
You too.
Okay. What's next?
Come on.
And that's reels. Okay.
So, that's it, is what it is.
Better than none. I was worried that we were gonna have a year with none.
Yeah. But then, well, I did want to see you here today. That would make it here from time to time.
Myself and Julia and Heidi, have you met Heidi? She's the other attorney at our home usurper. We're gonna.
Thursday class, they always bring it down.
Oh, good, I'm glad. Oh, that's great.
I insist there's only one question. Discuss it today.
And they do that. And they do that. That's it. I know that question. Great to see you.
Say a little stuff.
I will.
Jury's making trouble.
Always. I know.
Wouldn't have it any other way.
What else would you expect? All right. So I brought you guys the wills and trusts outlines, will for Barbary. And as I was telling Vince and Victor, if there's any advice I can give, if there's one thing you take away, it's you have to do Barbary. You have to do it. Sell whatever you have to sell. You have to do it.
I just bought it this weekend.
Okay, good. Now that you bought it, you have to do it the way they say to do it. There were some people that go, yeah, I bought Barbary, but they go, oh, but I'm doing my own plan. I'm studying their material the way I want to study it. No. These people have there's some kind of genius behind the design in Barbary that they have studied human behavior and how well we learn best. Just follow it and just do it. And like halfway through it, you go, I'm not learning anything. This isn't working. I feel like I'm spinning my wheels. Then you pass the ball. So you just do it the way they say to do it. In hindsight, you're like, oh, that was pretty neat.
So I was thinking about trying to do it over the second semester and then doing it again according to their program. So I guess doing it twice.
As long as you do it right before the bar, according to their program.
Right.
Because they layer stuff in your brain the way your brain learns.
Okay.
They layer it in there in a way that, I don't know how it works, it just works. You know, they have you learn all these subjects and then they'll have you go back to a certain subject and then do a new subject. They have you do lecture of one subject a day and then multi-states of some other subject at night. Or it was at night for me because I would try to get through all the material. I only got through about 75% of the material. You cannot do everything they say to do and pay attention. You could sit in front of the computer while it's just going on and not absorb anything, but I don't consider that time studying. When I realized it was time to put it away, it was time to put it away when nothing else was going in. Because you have to then recharge yourself for the next day. Because here it comes again. Yeah.
Sounds good.
You have to do it. and pass the bar. You guys could have 100% pass rate in your class. You could,
Hopefully.
yeah,
Hopefully.
you really could. That would be fantastic. Okay, so I want to start with the basics of a will and trust. These are our, there's actually 3 pieces of paper in here, 3 stapled together documents. This is what's called a standalone will. And the reason I want to start this way is because I want you guys to understand wills and trusts and the purpose of estate planning, period. Why do people come in and do these things? Why don't they do this? This is a will that we probated.
Nice.
So why doesn't everyone just do this? Why do you go to an estate planning attorney and actually fill out a will? So this is what's called a standalone will. This means you do not have a trust. Does anyone know why you would have just a will and not a trust?
Because you don't have a lot of assets.
How much do you need to go to probate?
Was it over 10,000?
150.
150?
Net or gross?
Gross.
It's gross. Yeah. So if your house is worth $151,000 and you have $100,000 of debt on it, it's going through probate for your kids to get the equity in it because it's based on the gross value. So if you do not have assets that are approaching 150, because even if it's approaching, oftentimes they'll find something out there that they didn't know about that'll throw it over the 150. So if it's approaching, you're going to recommend a will and a trust to your client. But if they have $50,000 and it's not approaching the where you need to go to probate, you can do just a will. If you're just trying to give away your family, china, some knickknacks, people really feel like their heirs want certain things. This is what scares me about family law. They think, oh, my daughter definitely wants my porcelain cat collection. We will write that in a regular standalone will. When it's standalone, it means there's no trust. Just you only have a will. So, and even though this is our prototype, and you think, oh, I'm just going to fill in the blanks, it's going to take 10 minutes. You sat with your client for up to an hour and really got to know them and learned about their family, why they're disposing of their property the way that they're saying they want to, who could potentially object to the way they're giving away their property.
So people not getting it?
We do will contests all the time. So I'll actually tell you about this case. And there was even a contest in that case. So a standalone will, you put the name of the person at the top, will of Nicole, I, Nicole, County of Riverside. If you have any children, you want to list out those children because they are that person's heirs at law. So we want to make sure that everyone knows who the parties are, who the players are. You even have to name a deceased child. That deceased child could have a child that could be your heir at law. That's where per stirpies and per capita come in. Okay. So disposition of personal effects. If you look at 4.2, page 2, that is where if my child or his or her issue do not survive me, I give the residue of my estate to. This whole disposition of residue is where we really, that could end up being a page long or more. That's where we really have to use our creative lawyer skills to draft it precisely in a way that we're giving each asset to each beneficiary in a way that if somebody else has this will, they can completely clearly understand what it is we were trying to accomplish. No contest clause, this is very important. This means that, let's say, your aunt gives you $10,000 in the will, and her estate was $100,000, and she gave your other siblings $20,000. If you choose to contest the will and say, that's not fair, one of my brothers influenced my aunt into giving them more and me less, it wasn't fair. If you lose the contest, you take your siblings to court and you lose your 10,000. So that's the purpose of a no contest clause, is to prevent litigation or strongly discourage litigation. We have to give that person enough in order to discourage litigation. If it's a $4 million estate and they gave you 10 grand and you might potentially get $1 million of it, you're gonna say 10 grand, I don't care, right? I'm willing to roll the dice with my 10 grand to get $1 million. But that's where you have to make those recommendations to your client. And you have to give them enough not to contest. So everybody, even though look at number 7, everybody, even though you're dead, you have to pay all of your creditors and all of your taxes. There are exceptions to that, but I'm not going to get into them today. Executor, you have to name someone, a trusted individual, or we also have recommendations for professionals that do this, to take this will, go accumulate that person's assets, and then give them to whomever they say to give them to. That's what an executor does. We like to name 2 or 3 executors as alternates, because the first one might say, oh, I did that for my brother, I'm never doing that again, because you get all the phone calls, you get the angry family members that don't think that they got enough, etc. Does anyone have questions so far? Good? Okay, so that's a standalone will. Attestation, the very last page. You have to have, or in order to be a valid will, it doesn't actually have to be witnessed, but we recommend that it is witnessed by 2 people. That's really best practices to make sure that person, when someone comes in and signs a will in front of us, we say, are you under the influence of anything today that would prevent you from having the capacity, from really knowing the amount of your assets and to whom you're giving them to? Are you under duress? Is anyone making you sign this will? You understand what you're doing, etc. We go through this list of things, and then 2 people witness that. So if this will is challenged, and they said, Vince brought my aunt in there, got her drunk, took her to an attorney, and had her sign this will, you now have 2 people saying, no, she was absolutely of sound mind. She knew exactly what she was doing, and this was the way that she wanted to dispose of the property.
Notarization?
No, you don't notarize wills.
Because that only says that the signature's real. It doesn't
That's right.
say that they're competent.
You can completely notarize a drunk person. You're just saying, yep, I looked at their identification and that is the person who signed it. That's it. So the second document is a pour-over will. It looks nearly the same, except you're going to look to Section 4, disposition of residue again. Do you guys understand what residue is?
So whatever's left over that
Right.
you didn't specifically name out in the will.
That's right. So there's specific bequests, meaning I give Vince my house, I give Victor my car, I give Will all the cash in my bank account at Unibank. Then
$2.
all the other residue, everything else is residue. Furniture, clothing, anything else that wasn't specifically named is residue. If you find another account out there, which happens all the time, if you find something else out there that goes into the residue, oftentimes people just say, everything is residue, and here's how I want it to go. Sell my house, sell everything, and here's how I want it to go. So this will is drafted in combination with a trust. This is the best way I know how to explain it, because this will pours your assets over into your trust. So your disposition section here in 4.2, 4.1, just section 4 in general. 4.1 is the pour-over provision. This just says, all my assets go to my trust, and then my trust says how to distribute my assets. So this will, a pour-over will, which is very highly tested, a pour-over will, just the beneficiary of your will is your trust. Then your trust says how you want things to go. Does that make sense? Okay. So that's the only difference really between a standalone and a pour-over. And we recommend a trust to anyone who A, has real property, especially here, it's going to be very unlikely that it's under $150,000. So anyone who has real property or anyone who has substantial assets. You get a pour-over will and you get a trust. We actually have other documents that go along with these, but we're not gonna go there yet. So what is the purpose, what is one of the main purposes of trust?
Their tax benefits, huh?
There can be. There's multiple different kinds of trusts, and we definitely do tax planning for people based on
I thought it was to keep it out of probate.
the size of their estate. That is the number one reason to have a trust, is so that you don't have to go through probate. Probate fees are statutory. It is 4% of the first 100,000, 3% of the next 100,000, 2% up to 800,000. And then I think after that it's kind of discretionary. So we recently had one where a guy had everything in trust, but the beneficiary of his life insurance policy said the estate of and his name. That doesn't go into his trust. It didn't say his trust. It didn't say a person. If it would have just said a person, his husband, if it would have just said his husband's name, no probate, because he had everything in trust. If it would have said his trust as the beneficiary, that money would have gone into his trust, and then his trust would have distributed that asset. It said estate of and his name. We had to probate the proceeds of a life insurance policy, $1 million. I think this was a $30,000 or $40,000 probate. And all we did was get the life insurance policy. We had to prove the guy had passed. We had to prove that we opened up a probate, proved that there was an estate with an administrator. The life insurance policy cut a check to the estate of.
Oh, that's why it was such a hassle, because of the
Right,
state.
estate of. It was not,
That's that.
right, it wasn't the Vince trust. It was
Yeah.
the estate of Vince, right?
Yeah.
And he actually had set up the beneficiary on the life insurance policy before he had a trust and just forgot to change it. And we tell people 15 times in our meetings to make sure all your beneficiary designations are looked at, how you want them to go, etc. And some people still don't do it. So we opened up a probate, just to marshal the life insurance policy, which ultimately went into the trust, which got distributed to the one beneficiary, but he had to pay over $30,000 just to go through the probate process. So one of the main purposes of a trust is to avoid probate. Probate's about 6 months if you have an efficient firm doing it for you, and it's a lot of paperwork. And the fees are definitely earned. Maybe not that big one, but the fees are definitely earned, but you want to avoid it if you can. So everybody should have, especially everyone who has any real property, should have a trust. Also, another benefit to a trust is the tax planning. Right now, the estate tax is anything over, it just was raised to 11.18 million per person. So if you have 2 parents, you have over $22 million of exempt assets that'll pass to your heirs without paying any estate tax. But it was 5.43 million last year, so now it's 11.18 million. It has a sunset clause, but if we get a new president, that could change. So you have to think, let's say you have someone coming in with $4.5 million of assets. You can't say, oh, you don't even approach the 11.18. We don't have to worry about tax planning, because that could end during that person's lifetime. So you have to think ahead for tax purposes. There's all kinds, I don't want to go too deep. There's all kinds of trusts. This is just a simple trust that says, here, I'm this person and here's how I want my assets to go. But there are other trusts that move money into sub-trusts to avoid estate taxes upon the first person's death. And that will have different beneficiaries than this trust. So there's different things you can do. I don't want to go crazy tonight, but just give you a true foundation for what is a will and a trust and why do people have estate planning. It's really to have an efficient disposition of your assets upon you passing that's not expensive and mostly efficient so that your children or whomever your heirs are don't have to go through the process, go hire an attorney. We have to file bank statements with the court. We have to take inventory of the contents of homes. It's really invasive. So avoid it. Have somebody do a trust. So that let's say that guy who had the life insurance policy didn't have a trust at all. He did. He just missed the beneficiary designation on the policy. But let's say he didn't have a trust at all. Trusts are a few $1,000s. Wouldn't you rather pay that than a $30,000 probate? And in most cases, the cost of forming a trust is far, far, far less expensive than even a modest estate. You know, a $200,000 estate, and that's gross, not net, is a $7,000 probate. Trusts are, in most firms, are far less than that. Okay. Any questions on a standalone will, a pour-over will, or trust?
Yeah, there's a couple differences, like the guardian is a part of this.
Yes.
How is that different than an executor, and why is it named in the will, not just in the trust? That's something you just assign to the trust and now all be in the trust.
No, in a will, you're gonna name potentially a guardian for your children.
Oh, okay.
So if you have minors, and that's why it's different than an executor. If you have minors, or we can even do a pet guardian, you wanna keep in mind your pets also when you are talking about who's gonna take care of things when you pass away. So the executor goes and takes all your assets, opens up an estate account, puts everything into the estate account, and then distributes it to the beneficiaries. A guardian takes your children.
Okay, so and that can be in a standalone trust at times.
Will.
It's in a
A
will,
will.
yeah.
Okay,
Correct.
it's just not in this one.
Yes, yes.
Okay.
And these are just our
They're
simple
examples.
prototypes, yeah, we have to customize them. So even with all this done, it can still take hours to draft somebody's will or trust, even with all this done, but we have to customize it. If they have children, we probably have a standalone prototype that says with children. We probably have one of those. We don't use standalones very often because most people, most people
If they're coming in to an attorney, they probably need a trust.
most people do, yeah.
Yeah.
I've done a couple just standalone wills, but it was interesting circumstances. So one of the things the book talks about is how can you pass an asset outside of probate?
Well, you can do it before you die.
Yeah, in vivo or something.
Inter vivo's good.
That's true.
There's also like life insurance.
Well, yeah,
That's
there's the
that's
out of
probate.
probate assets or whatever.
Is that what you mean?
Yeah, so
Okay.
out of probate assets, you can do a pay on death deed on your house. So when you pass away, it just automatically goes to the person who transfer on death. Sorry, pay on death is a bank account. Transfer on death, a TOD deed. So you can have that on your house so that when you pass away, that person, I'll just put Victor as my transfer on death person on my house. And when I pass away, if you knew that you're the person who has that deed, you just go down to the county, record my death certificate, and the house is now in your name. No probate. You can put a joint tenant on your home. I don't recommend that unless it's a husband and wife, and even then one of them could pass at the same time and then their house is subject to probate. Oftentimes people say, oh, I don't need a trust, I put my child as a joint tenant on my house. What comes along with assets? Liabilities. So if that person gets into a car accident and is successfully sued for more than the value of their automobile insurance, they're gonna go after your personal assets. Your house is on your name is on your mom's house only for estate planning purposes, but it's your asset and they're gonna try to take it. So I never recommend that to people. They think it's a way to avoid probate and avoid having to pay for a trust, but it really could create potential problems with liability. Anytime there's a creditor of that person, they can attack your house. They quit paying their credit card bill. They end up dating a loser. It happens, and their name is on that house. So I cannot recommend that as an estate planning tool. But let's say you're husband and wife, joint tenancy, one of you passes, the house automatically goes to the other person. You still have to file something with the county, but it avoids probate.
most life insurance policies or another way, because then you just when you can designate a beneficiary,
Yep.
right?
Same thing on bank accounts. You designate a beneficiary and it avoids probate altogether. It just goes to that person. So we always recommend that to our clients, especially with bank accounts. Especially if there's just one beneficiary or your two children, some banks let you have two pay on death beneficiaries on a bank account. That avoids probate. Let me look and see where that was. Let's try to flip through this.
I think it's like the first chapter.
Yeah, we're only doing chapter 1 tonight. Heidi's gonna take chapter 2 next week. So one of the things that I learned in my wills class was that it took a month before the concepts of what we're doing in estate planning really sunk in. And I don't want people to get lost in all these cases when it's may or may not apply to what we do today or help you pass the bar. So freedom of disposition. You can give your property to whomever you want. That actually is a good segue into this will.
But it's still within limits, right? Even though you have the freedom of, because like even when they were talking about, which I think is chapter 2, but like the Slayer statutes and stuff like that, there are some states where even if you say, regardless if they kill me or not, I still want them to have
It's
it.
against public.
And then some states will still be like, yeah, no.
Right.
Ron Swanson will.
We were just talking earlier, it's euthanize my cat euthanize my cat when I die. That's against public policy. That's not okay. You can't do that. So the court can, that was in here. It was in one of the little sub areas. But the court can just take out that section. Yeah, they can take out just that section of your will and find the rest of it valid. They can do whatever they want.
Is there like a principal part rule like contracts? Like if it's like the major part of the, like let's say a house like 90% of it and you're like, give it to somebody who kills me or something. Like, does that destroy the rest of the contract?
No,
No? Okay.
like if they give 4 or 5 different things to different people, but the main asset was given to somebody who killed them,
Right.
they're not gonna invalidate the whole will.
Okay.
They're just gonna say, we're not doing that.
Okay.
Just like this lady in here that said euthanize my cat. They
did everything else.
They did everything else, but they just said, oh, we're crossing that out because that's against public policy. Same thing when somebody challenges a document or part of a document. It's my favorite part. I have stories for days now. So as an example, Guy signs a will 4 or 5 days before he dies. The will gives everything to his former boyfriend. The will says, if former boyfriend does not survive distribution of my assets, then, because probate takes 6 months. So if the guy doesn't survive until the end, when he actually receives the assets, then my assets will go to my heirs at law. Guy died.
Sucks to be his heirs.
Decedent died? No, it's good to be his heirs.
Well, no, it's good to be the original dead guy's heirs.
Yes,
it
but
sucks
not
to
the
be
second dead
the
guy's
former boyfriend's heirs.
So we filed a will contest the second this will was, we represent the heirs at law. Apparently, Guy's ex-boyfriend showed up a month before Guy died and started kind of
Coaxing.
that's what our theory is, right? Do we know what happened? Not really. So a month before Guy dies, he shows up and starts helping him out, ex-boyfriend, who's now married. So Guy leaves everything to ex-boyfriend. They file the will. They open up a probate and file the will with the court. And we immediately, as the heirs at law, file an objection saying, no, this was undue influence. This guy was on hospice. He didn't know what he was signing, right? We went down the list of all the ways that you can contest a will. So then, beneficiary boyfriend dies, which we weren't expecting, 53 years old. right? We were not expecting that guy to die. He dies. Then we go back to the will and we're like, oh, now it goes to our clients. We withdraw our contest, right? We're happy for this will to move forward because now our clients get the assets. Attorney for second dead guy, right? The executor that was the beneficiary, attorney for him has threatened, he hasn't done it yet, but he says, I'm gonna file a will reformation. I'm going to say that is not what the decedent original dead guy intended. That I, as the drafting attorney, made a mistake by giving it to heirs at law if boyfriend didn't survive, because that was not dead guy's intent. His intent was to give it to boyfriend's husband.
He has a conflict of interest.
Yeah, for real.
Just no practice to himself to win the case.
Yeah, whatever.
Right. So, point being, he's trying to just change one paragraph in a will. The rest of the will, he's like, yeah, it's good. But we're like, but dead guy signed it. So did he not read it before he signed it? Did he not understand it? So anything that attorney says is basically not in support of his case. So we're just waiting for that to be filed to see what he says, but he's filing a will reformation saying that that was not truly the original decedent's intent.
I filed to have him removed from the case as a conflict.
I think that's a great idea.
If he does that, you
I'm gonna
know?
write that down. Yeah. I'm gonna write that down. So he was the drafting attorney, represented, so he represented decedent, now he's representing executor, now he's representing executor's husband.
While trying to say.
And he's the main witness.
Yeah, and he's the
That's
main
what he says.
witness
He said,
of
you know you're
the
gonna
dead
be
guy,
opposed.
the original dead
Yeah,
guy.
you know that we're gonna call
To
you
his
a
own
husband.
financial benefit, let's be honest.
Well, yeah,
You know, like, it's a big conflict.
I'm gonna research this conflict. So I'm glad you said that. Okay, so when we say we can leave our assets to whomever we want to, read if anyone could read me like the first couple of sentences.
I leave 60.
60%.
Go ahead.
I was like, I leave 60% to my 2 dogs, and to have Steve Weeks to feed them, keep them together, and whatever is necessary they need. He can
You can reach Steve Weed at his phone number.
Yeah, there's this one over 10%. We'll go to the remaining people. I can't read that.
Crystal Morgan,
Crystal Morgan.
Rona, no last name, Ray Hendricks,
Oh, these are names in there.
Kaufman, which is
Kaufman.
actually Rona's last name,
Oh,
and
so it's Crystal Morgan, Ray Hendricks, and then Rona's supposed to be below.
yes,
Rona
Kaufman.
Kaufman.
and Rebecca Fearing.
Mm.
My request is to be buried beside my dad at Forest Lawn, Hollywood Hills.
Okay. That's pretty fair.
Did her 2 dogs get 60% of her estate?
No, that's not the intent. The
Yes,
intent-
they did.
Well, yeah, they did.
No, the
You
intent
can-
is to give it to Steve Weeks for the protection of the dog.
No, it's to leave the 60% to the dogs, and then the dogs get left to Steve Weeds, who's to use that money to take care of the
So
dog.
how do you do that?
Will you put it in, I would say, as, I don't know if a bank would open it, but you basically have to do it as kind of like a minor trustee or a conservator trustee account with the dogs as the trustees, the beneficiaries,
Absolutely.
and then the human as
The trustee.
the trustee,
That's right.
and then the human becomes the beneficiary, the successor trustee as well, because he's the one who gets whatever is remaining, probably.
That's right. Well, no, that's not right. So,
Oh,
but,
I thought when the pets died, whoever took care of them got the money.
so that's what the court took issue with. Because, let's just be real. What if Steve is like, so how much do you think 60% of her estate was?
Based on this well. What? $60? Actually, no, she probably had a ton of money.
$90,000.
Not a ton.
So the dogs
Good
are gonna be
enough.
walked in Hawaii like every other month, right?
Yeah, exactly.
So,
It's arthritis. I mean,
and the dogs, they weren't puppies, but they weren't seniors. I think they're golden retrievers. They're bigger dogs, so they have a life expectancy of what, 10, 12?
Yeah.
I want to say they were between 5 and 8 years old. We got this will when I was a 4L, which was in 2016. Might even have been the fall of 15, right? We got this will in class, and Julia said, what would you guys do? This is a case I have right now. And I really wanted to figure this crap out. So she said, the issue the court has is that the court wants your money to go to your heirs at law. This lady, Mary Draz, who passed away, her closest living relative were aunts and uncles in like North Dakota she had never met. She wanted her dogs to be taken care of. So then I went to work for Julia, and guess what file got put on my desk?
No.
This one. So what we did was set up a pet trust. That's a thing. And the Steve died, so Steve was no longer a candidate for being the trustee of the pet trust. Rebecca stepped up and said, I'll be the trustee, I'll be the guardian of the pets. I'll take the pets and I'll take care of them. Rona said, okay, I'll be the trustee of the pet trust. We had to get it all court approved. So there is an account that is the Goldie and, is their names not on here?
Andre and Goldie.
Looks like
or Goldie.
Angel.
Or, yeah, Angel. And
Yeah, Angel and Goldie, the Angel and Goldie Pet Trust. And
Lee.
there is an account at a bank that is the Angel and Goldie Pet Trust. Rebecca takes care of the dogs. Rona, as the trustee, oversees it and sends, Rebecca has to say, here's how much money I need to take care of the dogs. Here's their vet bills. And Rona pays out of the pet trust all of the bills, all of the care. She gets a monthly amount just for food, for housing, like putting a roof over their head. And then any expense that the dogs need, it's taken care of. Rona, as the trustee, she has to answer to the heirs at law. The beneficiaries of this trust, after the dogs pass, are the aunts and uncles. And that's the way we got the court to approve it, because they want to honor Mary's wishes that her dogs get the money, but then the pet guardian doesn't get what's left over. The aunts and uncles do. If these dogs died tomorrow, how much do you think is going to be left in the pet trust?
Like 85,000.
Nothing. These ladies are spending this money like they are rock stars.
Ah.
All in the name of the dogs.
Fancy everything.
The dogs need to go in Hawaii, I think.
Yeah, I do too.
Yeah.
And if the trustee says that's okay, that's what they do. There's no one looking over them. But if the remote aunts and uncles,
Can't they ask for like a court audit or whatever,
They
like
could.
the book was
they
talking
absolutely
about?
could. They absolutely could.
But they probably don't know and they don't care.
Right.
So
Do they know at this point or no?
I don't think they even know that they're the beneficiaries of the pet trust. We had to send them all our documents, but literally, especially if you're a probate, they must have a stack of envelopes from our office this big, full of all these motions, everything we ever filed in the probate court. You think they're going to pull it out and read a pet trust and see that they're the beneficiaries of the pet trust? No, they're not going to do it.
We can see if they call up to the dollars and the
Right, but that's what Mary wanted. So yes, you can leave your property to anyone or any furry one.
So what happens to the other 30%
yeah, that's
though?
exactly what I was asking.
Well,
Because
so-
it's only 70%.
So that's what we also had to get the court to approve, and the beneficiaries, the 4 beneficiaries, objected to our petition to the court. It says here, 10% will go to the remaining people, Crystal, Rona, Ray, and Rebecca. So that makes 100%.
Yeah.
So we said, Your Honor,
Oh, 10% to each.
to each.
Yeah.
Oh,
She didn't say
okay.
that, so we had to get court approval that that's what she meant.
Mhm.
But Rona and everybody objected. They said, no, give it all to us, or something like that. And that Rona, Rebecca, Ray, and Crystal should be the beneficiaries of the 60% after the dogs pass. They said they should be the beneficiaries. And we said no, right? We were kind of advocating for the dogs. So it's all set and done. We got this probate closed. It took 2 years.
Wow.
There was so much stuff. This lady had so much stuff. She had Pee Wee Herman doll. She had so much stuff that we had to inventory it all and get it going. So you make money on the $30,000 life insurance probates. You'll lose money on these probates because this just took way too much time for we would call this a modest estate. Her house sold for like between 150 and 200,000. Then there's fees and all that stuff. Anyways, so yes, you can give your property to anyone. Do you guys have questions about that?
So they're just blowing money on really expensive documents?
Of course. Yeah. I mean,
diamond studded collars that I will in turn pawn in for cash.
So yeah.
I mean, really, you could fly someone from Japan to the United States.
The groomer.
To babysit your dog while you go to the beach for the weekend, and unless the aunt and uncle object to that and say, no, that was kind of an excessive expense.
I doesn't like to fly, so when we go to Hawaii, we can cruise there.
Right. Well, we just fly everyone here, right?
The dog can't be left alone, so the dog's gonna come with them.
They're gonna have reasons for everything. And Rona's an attorney, so she's gonna be a creative, trustee. She's gonna be like,
how do we know
yes,
that this is not like a,
Well,
obviously I think it's an old person's writing.
So we also submitted to the court samples of her writing.
But she didn't sign it or anything, I mean, it's goofy,
Her
man.
name's at the top, and the court accepted that
it's a signature.
as that this was hers. But here's the thing, Will.
It's all about intent, I guess, right?
Unless somebody objects, so the only people that had standing to object are her heirs at law.
Who don't even know she exists.
The people in this, if they object and get this will thrown out, they get nothing. So they didn't object to this as being her will.
Sure.
So unless you object, the court's gonna go ahead and say, yep, this is her will. I mean, there's one that was done on a napkin, and you literally take it to the court and you file it with the court, and they take the original and keep it forever. And you get a copy of it. You can write a will on anything. The only time it's not going to be accepted as your will is if someone objects. So, this is the very least every single one of you should do. This is the very least, is to have a will dated and signed in your own writing and give it to a trusted person.
You want to do mine really inconvenient now?
Now I'm gonna have to type
That's
all,
like a 40-pound plate. And just
Yeah, absolutely.
I'm gonna have to type all this stuff out, like.
Here you go, Judge Adams.
And then you also have to submit to the court with this. You type it out and you say, here's what I think it says, so that the court can
Read it.
read it in typing, typed.
So they want it handwritten.
They want this, but then we typed it as the attorneys for Mary Draz, for the estate of Mary Draz. We typed it out, and there's a court form that you have to submit with the typed version. You say, here's what it says. And then
Can I
probate
only do
examiners-
the typed version?
Can you do a video?
Oh, yeah.
Okay.
Yeah.
Okay, it's just if you have this, then, okay.
If you only have
I'm
that,
just
then you
saying
have to
this is
transcribe it
yeah.
for the court.
Then you have to transcribe it for the court. Yeah. So that they can take your word for what it says rather than them having to interpret like this
Angel and Goldie.
to feed them with it back and stuff, right? That's that. Okay.
So you can do like video wills and stuff too.
The courts basically want you to tell them how you want your property to go. They want you to tell them. Otherwise, you fight. Okay. So I think the purpose of chapter 1 is to say you can give your property to whomever you want, but not if it's contrary to public policy. Like gay man told to marry woman or son would lose inheritance, right? You can't do that. Or there was another one about you have to marry a Jewish wife.
They said that was okay.
Yeah, that is okay.
Jewish wife is okay, but not if you know.
You have 7 years, and you'll find someone, or if you don't, you don't.
So they're going to make all these arguments of what is okay for public policy, but in the case where there's the Jewish wife, why do you think that was okay?
They wanted to promote like the culture.
Mm-hmm.
I think the one where it was like, I think the one where you knew the son was gay, but wanted to marry a Jewish wife with Jewish parents.
Yeah, that one they said that he couldn't because
Right.
they mandated that he married a woman, and they're like, no, you knew.
Attorney Ann wrote that the stipulation Robert Mandelbaum marry a woman was tantamount to expecting him either to live in celibacy or to engage in extramarital activity with another man, and is therefore contrary to public policy.
Yes.
So you have to think. But encouraging someone to marry in your faith and to keep your practices of your faith alive in your family is found to be public policy. That's okay. But honestly, I think it's situation to situation. There are no two exact same fact patterns. Because I thought Will's Trust, we do a lot of litigation, but I thought it was transactional. I truly thought I was signing up for a job where I was like going to draft people's estate planning all day long. No, it is fighting. It is, yeah, it's gloves off. I'm fighting my family members for this money. And you just see an interesting side of people. But it's all, every fact pattern is so different. The only thing that's the same is people come in extremely distressed. Do you work in the law?
No.
But you guys do. You two do. You're still with Blaisdell?
I'm still close to.
Awesome. How's that going?
Going really well. Yeah, we're busy.
I know. Like so busy you could just stay there for days, right? Weeks.
Yeah. I mean, I'm always out of there by about by noon. Yeah, you know, it's I could just
Work forever.
I was as fast as hard as I can while I'm there. Yeah.
My first year of being an attorney was harder than all 4 years of law school combined.
Oh, sure.
Yeah.
Yeah.
Just pulling your hair out. Yeah. This year's like half that hard, but still.
Still not easy.
Yeah. But I try not to lose sleep over somebody made me mad that day, which you have to, that's a skill you have to learn, right? Because other attorneys are mean. And especially when they look up your bar number and they're like, oh, I'm going to get hurt, right?
Mm-hmm.
Yeah.
It doesn't even say what school you went to.
3, it doesn't?
No.
I think it
It
does.
says C registration card. Because I looked it up for you, Anthony, and Kelly.
Yeah.
Because I wanted to see what it says, and it says C registration card.
Oh, because
Because it's unaccredited and it's so new.
CDTA doesn't even have a drop-down menu, probably. Yeah, that's interesting. But I will tell you guys, I think I mentioned it to all 3 of you. I went during the summer before 4th year. I started a program at Harvard for certificate in legal studies, and I finished it just this last December. It took 3 years, but I didn't go to school during bar prep, so I took that semester off and then started again in the fall. One of the reasons I did that is because I was thinking clients are going to ask me where I went to school. They're going to go, where? Right? And then I'm going to be able to say, but then I continued my education at Harvard, right?
Nobody cares.
Nobody cares. Nobody has asked me in a year and a half. Not one person. Not one. Nobody. And I practiced before Judge Evans. He didn't care. You know, he's clearly a supporter. So nobody ever asks or cares. I was surprised by that. So that's why I mentioned it. I was surprised that the only people that look you up are other lawyers.
Yeah.
That's it. Okay, Boots, the 11-year-old cat, they would not let them euthanize the cat.
We'll just donate their guys' money to shelters and stuff too. So. I found the page you were looking for was 42 for the whole POD thing. The joint tenancy and all that stuff is page 42.
Thank you. Yep, here we go. Okay. So start on page 41 with our friend Bill Cosby. So let me just make sure there isn't anything else that I want to make sure that cover. You guys, I don't know what Julia and Heidi are going to do, but I really want to focus on you guys understanding the concept of wills and trusts. Because I was telling Will, I was telling Vince and Victor before you got here. I feel like one of the issues of people that were not able to pass the baby bar, and I don't know about the bar, but that they're just spitting out definitions and not understanding them.
Sure.
Not taking the time to say, this is the rule, and really understanding how that rule would apply to a fact pattern. It was just memorizing, but not getting to the next level of really understanding. So I want to make a huge point in making sure you guys understand the concepts of wills and trusts, because I feel like you're so much better prepared. You can make that rule up during the bar if you understand what it is. If you just understand the concept, you can make the rule up. You really can. They're looking for form and reading your analysis far more than they read it on the baby bar. So I want everyone to understand what wills and trusts are, the purpose of them, and then in a couple of classes from now, we'll start going over the rules so that you know what rules to focus on. Because as I mentioned, did you hear when I said how many times it's been tested?
No.
This is in a 10-year period, this only goes up to 2016, but in a 10-year period, trust was tested 8 times and wills was tested 10 times. It is a highly tested subject. 2 separate subjects, but very highly tested. And I think my class made it more confusing than it needed to be. So
Start simple, then get
relax
complicated.
about it. Yeah,
Mm-hmm.
yeah, start simple. I'm not gonna give you guys a specialty exam, but Julia gave us a specialty exam for our final exam. Like what attorneys take after they've practiced for 5 years.
Okay.
She gave us a specialty exam.
Sounds like fun.
I'm not gonna give that to you guys. It is very likely that your essay will, your midterm and your final, if I write them again, will mimic some Barbary essay from some time in the past, because that's the library of essays I have. And they test so well. So Barbary, you know how when you're here and you write an essay and love Drucker, like Drucker go, 65, but doesn't really tell you why, right? Even your professors, they give you grades and they don't always tell you exactly why, right? Barbary gives it to you by the point. You got 1 point for listing the exception to this rule, for talking about it. You got 3 points for this, for finding this issue. You got 5 points for this issue. This was an 8-point issue. They list those things out and tell you exactly how many points for each element of the essay. It's not the right element of a rule, for each rule that you listed and argued in that essay. So you can start managing your time, right? When you see that certain things are so low point, are you're rewarded with so little points each time that you're writing that essay, it needs to go further down on your list, right? Hit the main things. Barbie teaches you what those main things are. And they literally in their essay books tell you. They give you the essay, you write out the essay, and then they, on their scorecard, they tell you exactly why you got the score you got. It's really good.
So I noticed here, trusts are notarized, right?
Yes, trust or notarized,
And then the way to pour over will, that pours into this trust.
correct. And we do not notarize wills, but we witness them.
We witness this, and then that pours over into this.
A pour over will says, a pour over will primarily says, all my assets I give to my trust. And then your trust says to whom they go to. But we will sometimes, in both a standalone and a pour over will, always in a standalone, sorry. Sometimes in a pour over will, we will say, I just drafted one that said, my Harley Davidson to my son, and then all my other assets to my trust. Because he feels like his son would want, his Harley is just because he has 3 kids. So he wants his son to first have his Harley, then all his assets go to his trust, and his trust then distributes equally to his 3 kids. But his son got the Harley off the top.
Sure.
Yeah.
I have heirlooms that need to go back to my cousins. They don't belong to Sandersons, they belong to Mixons, but they're mine, but it's not proper in the long run,
Right,
you know?
exactly. So you list those things out.
Mhm.
There's all kinds of interesting things that people think, a Harley's pretty cool, but there's all kinds of things that people think their kids or certain family members really want. And it's sweet of them to give them away in their will, but primarily when someone passes, people are calling saying, where's money? Just like in family law, if you practice family law, it's a rude awakening to people.
It's all money.
They
So
just,
everybody wants.
they just want the money. They will step on their siblings, their aunts and uncles, especially if mom or dad got remarried. Give them the money. Yep. Okay, so start on, that's 30. What's your constitution, non-voting shares, okay. So page 41, the mechanics of succession, probate and non-probate property. So as we've discussed, anything that's going to reach up to, get close to $150,000, we're gonna open up a probate. Does everyone understand what that means, open up a probate?
You just file it with the court that somebody died, right?
Yeah, you file a petition, it's like 4 or 5 pages long, and then there's all these attachments like a death certificate, a list of the heirs at law, how each of those people are related to the person who passed away, the decedent. The court really wants to make sure that this person's property is all accounted for, number one. Nobody hid anything, which they like to try to do. And number two, that it's going where it's supposed to go. There are a team of probate examiners. No other area of law that I know of, no other judge, judges have clerks, but probate examiners examine all your paperwork. The judge doesn't have to look at it. The probate examiners examine all your paperwork and then they give a recommendation to the judge. We get notes a couple of weeks before our hearing that says, oh, you didn't check this box, or you're missing this form, or you failed to file XYZ, and you have to correct it 5 days before the hearing, and then you get clear notes and the judge lets you move forward. But there are probate examiners, specifically their job is to make sure that all this person's property is accounted for and then it's going where it's supposed to go. I mean, we had one where, let's see, this lady drafted her will in the 70s. In the 1970s, when she was already an adult. She passed away last year. All of her property went to her 7 siblings equally. 4 of them had died. So then their children get their share, right? Does that make sense?
Mm-hmm.
So her siblings, some of them had passed, so their children, which would be her nieces and nephews, get their share. 5 of the nieces and nephews had passed. This lady was like in her 90s when she died. 5 of her nieces and nephews had passed. So then their children would get her siblings' share, right? And this is when it goes per stirpies or per capita.
Now, does California follow one or the other, or it does depend on stuff, or?
Which one is which? Per stirpies is.
The one
First stirpies is
mine
when
was, it's when the children get the parent share exactly.
So we follow per stirpies,
Okay, cool.
unless it says
That's
otherwise.
easier for you to.
Yes, because it'll.
yeah, that's easier to understand.
But it'll say, if so-and-so passes before me, or doesn't survive distribution, like that one will, right? Then their share shall lapse, and it will go back into the pot for just that level. It will not go down to the next generation. So unless it specifically says their share shall lapse, or other terminology that would mean the same thing, then we are a per stirpies state. So my point being, there were 14 people who had predeceased this lady. We filed the probate, and the examiners had a question about, like 3 generations down, whether or not somebody was listed. I mean, I'm just saying that as an example that they really dig in and make sure that every single person who is supposed to receive their share of somebody's estate is listed and gets notice and has the ability to object. So that's the court's job, to make sure that all the assets are accounted for and they go where they're supposed to go. The judge does especially Judge Evans, he knows every case. When we get up there, I start reading the case the night, if it's not my case, that Julia and Heidi are like, oh, go to court on this one. I start reading it at least the night before, because I know Judge Evans is gonna ask me a question that I better know the answer to, because he reads everything.
He's my favorite judge.
He's awesome, yeah. He reads everything, and he has some very good questions. One time I had to ask him to put me on second call because he asked me a question that wasn't in the file. Like, oh. So I went out, called Julia, went back in, and we got that cleared up. So that he's really great. And the new edition of this book, you guys it'll be past you, but who wants to bet $5 that Bill Cosby will not be in the next edition of this book? So he wanted to know, so we have these questions all the time, and this is probably not going to be on the bar, but we have these questions all the time, like, what is part of somebody's estate? So he was trying to get, your likeness as, right here, many celebrities owe aspects of their public persona to celebrities of a prior generation. Doesn't Britney Spears owe a debt to Madonna, who in turn owes a debt to Marilyn? So that's what they're saying. Basically, can somebody's likeness be an asset in their estate? No, it really can't. At least not pursuant to this law. So a descendable right of publicity and the dead hand. So that was a good example of Britney Spears and Madonna and Marilyn Monroe as how ridiculous can this really get? You can't really quantify it. So there's things that are arguably part of somebody's estate, not part of somebody's estate, because here's what happens. We file a probate for John, and John's heirs, and John's new wife is the executor of the estate. John had kids from a prior marriage. I'm just making this up. This happens all the time. And the kids are like, she's not accounting for everything. There's got to be more. There has to be more. So we have to go through what are considered the assets of a probate estate. And wifey says, oh no, that was mine. I don't need to account for that. Well, show us, right? There's a big public policy towards making sure that all the assets are accounted for. Okay, probate and non-probate property. Inter vivos trust, when property is put in trust, the trustee holds it for the benefit of one or more new beneficiaries. Oh, let's see. When we draft a trust and that person is still alive, that trust is not its own entity. That has your social security number. You go and open a bank account in the name of your trust at a bank, it's under your social security number. It is not a separate entity. So that is you. That trust is you. It just allows you to avoid probate. It does not allow you to avoid creditors. If you stop paying your credit card and you're like, oh, they can't get me all my stuff's in trust. No, that trust is you. It's different when you pass away. Different laws come into play, but it's not hiding any assets from anyone. So an inter vivos trust, you're putting your assets in that trust, but it's still you. Life insurance. The proceeds of a life insurance policy on the decedent's life are paid by the insurance company to the beneficiary named in the insurance contract. So life insurance is not an asset unless you have one of those life insurance policies that grows money rather than it's just a death benefit, but it is not an asset. You can't give away a life insurance policy. The only time it has any value is when you're dead. Right? So that's why it's saying that it is outside of a probate process, because you name a beneficiary, you can name your trust, but you name a beneficiary, and that is not you don't probate a life insurance policy unless someone names your probate estate as it's the only time we've ever seen that happen. Does that make sense? If you name a beneficiary on some account or life insurance policy, you don't have to go through probate on that because it named someone it's giving it to. You don't have to get the court to bless that. You did it. The bank doesn't care what the court has to say. The bank says, she named Vince, the money is going to Vince. We did have an interesting case, and this was actually a very similar fact pattern was on the bar. We had a case, husband and wife are married. She names husband as beneficiary on her checking account. She dies. Husband comes forward. Kids try to go and get the money. 3 kids, not husband's kids, her kids, go into the bank to get the money. And they say, the bank says, sorry, there's a named beneficiary on this account, and it's not you kids. It's this person who's the husband, ex-husband. So the children come to us and say, you know, she divorced him. She didn't intend to leave this money to her husband. She divorced him. She must have forgotten that the beneficiary named on this account was him. She must have forgotten that because she doesn't want anything to do with him anymore. There is a probate code, no, there's a family code that says if a divorce is in the middle of the naming of the beneficiary and the death of person. So she named the beneficiary, her husband, then there's a divorce, and then she died. That it is invalid. That beneficiary designation is invalid.
Say it again?
Okay. This was tested actually on my bar. So if you name a beneficiary as your spouse on your account.
Or spouse as your beneficiary.
Yes.
Okay.
You name your spouse as the beneficiary of your account. Then you get a divorce. Then you die. That beneficiary designation is invalid. The law presumes that you just forgot to change it. Because if you still wanted that person to be your beneficiary, you may not have divorced them. So we had to sue the Union Bank and say, here's the code. Do not give $162,000 to ex-husband who's in jail. You need to give it, that was just a fun fact of this case. You need to give it to the kids because of this code. Union Bank said, we need the court to tell us that.
Yep.
So Judge Evans told Union Bank, you have to give it to the kids.
You know, when I worked at a bank, we had someone come in and they brought us in the will, and that's normally all it takes. And then, so we sent that for a legal department, and they said, okay, give out the money. It was like almost $300,000. And then her kid came in the next day and said, we have the will, we want the money. And the will was different from what just got brought into us.
Oh.
And we're like, we have the check cut. They're coming to get it.
What do?
We put the money back in the account,
Yeah.
and legal froze it and said,
Get the
bring us a court order.
Yeah. Yeah. That's all
And
you
pissed
do.
everybody off. But
Yeah.
you have 2 different wills out there. We're not going to go based on one word or the other.
That's right. Because especially when there's competing wills, the court has to say which one is being admitted. And there's going to be objections filed, and to whom did each will give?
One was to a son and one was to the daughter,
Yeah.
and the son was supposed to be estranged, but he said that the daughter, she was psycho and she was convincing her mom all this stuff.
Yep.
And
Undue influence. Yep.
so we're just like, we don't care.
Yeah. So I have a case right now where 67-year-old male writes out to his one daughter, I give you my condo in Palm Desert, and writes a bunch of other stuff in November. In January, he gives the same condo to his housekeeper, holographic will again, just in his own writing. And then a couple of months later, he gives the contents of the home to someone else, his car to his daughter, and a percentage of interest in another house in another state to another daughter. Now there are like 5 different writings that we potentially need to combine in to say this together is his will. Oh, and then he commits suicide. So of course the daughters are challenging, the housekeeper runs down to the courthouse and files that handwritten will with the court and says, I get the house. And now the daughters are of course objecting to that. I have the daughters. I wouldn't represent the housekeeper in that one because I just wouldn't do it. So there is a rule that anytime you're going to give anyone any caregiver more than $5,000. And a caregiver is defined, this is one of the reasons I like estate planning is because there's the code, the probate code. It's like, okay, what's caregiver? You just go to the code. What's this? You just go to the code. So a caregiver is defined as anyone who provides services for an elder. An elder is 65 or older. So a housekeeper, even though they're not changing diapers or giving baths to this old guy, she's providing a service for him. You cannot give them anything over $5,000 unless you get a certificate of independent review. So if that guy came to me and said, I want to give my housekeeper the house, I would draft his will, give the house, or a trust, and in it, give the housekeeper the house. But that guy has to go meet with another attorney. That attorney has to fill out a certificate of independent review, says, I interviewed Vince. He was of sound mind. He understands that this is his housekeeper and this is not the natural disposition of property. Like, right? He understands that he's not giving it to his daughters, he's giving it outside the natural disposition of property. And I feel as an attorney that is truly what he wants to do. Then you sign a certificate of independent review, goes with your will, and you're good to go. Yeah, this guy didn't do that. So it is presumed that anyone providing services for an older person has undue influence, has the ability to unduly influence them because they're around. Old people are lonely. One child in Orange County, one's in Florida, they love their dad, they call him all the time, but who's there every day? Taking his dog to the groomer, picking up his dry cleaning, telling him how great he is, making him dinner, right?
What's is that just in probate or is that in general?
What do you mean?
Where's the presumption? Like, do you know I actually really want the case or the code section that has a presumption for a different reason.
I'll send it to you.
Okay, cool.
Yeah, I don't know the probate code off the top of my head.
Is it just probate though, or?
Well, give me a fact pattern.
Complex elder abuse case.
What elder abuse cases? In an elder abuse case, you would go to the probate code.
You would.
Absolutely, and there's also criminal codes that complement the probate code. Is it?
I'll talk to you later. Yeah.
Okay. Is it being prosecuted, or this is just a civil suit for elder abuse?
I'll talk to you later. Yeah.
Okay.
Civil suit.
So we filed it. So this lady runs down to the courthouse and files the will. It's like, this is old guy's will. I'm getting a house. So in our objection to that will being admitted, one of my causes of action in the objection is elder abuse, because this old guy was paying this girl's mortgage. He was giving her $1,000, $2,000 at a time. When he died, he had $17,000 to his name. He could not afford to do what he was doing. So I think that is evidence of influence, and elder abuse is in this case is financial elder abuse. Mm-hmm. But I think that is evidence, strong evidence. He couldn't even afford to take care of himself. And here he is paying her all this money and buying her kids school books and taking care of her because he felt responsible for her. Because she clearly, in my opinion, because I'm representing the daughters, she was playing like the damsel in distress and, oh, I need your help. And just kept taking money from this guy. Mm-hmm. Not okay. You do your job, you get paid to do your job, and you go home, no matter what your job is. You don't stick around and see what more you can get. I don't like those kinds of cases. I don't like it. There's a point where someone is generous to you. There's a point where it's too far, and a rational person says, that's too much. But they just keep taking and taking and taking. We just settled a case in April where the caregiver had the old lady sign the house over to her before she died.
We have 6 properties that the guy took.
Yeah.
Over $2 million.
Yeah. Who is the guy? Where is he?
Palm Springs.
He's still around?
No. The bad guy?
Mm-hmm.
Yeah. I think so. He's still around.
Is he a professional caregiver?
He's just a shyster. I mean, I don't know. He's not a professional.
What relationship did he have to the old person?
met through a friend and weaseled his way in, and then had him like slowly signed over property for.
Was he acting like he was a significant other, lover?
No, just a
Running
business
errands for
partner.
him? Business partner.
Just like trying to, yeah,
How old is your client?
dead.
Dead.
Oh, in 90.
Total elder abuse. Did you go to the elder abuse conference? No, I didn't see it there.
I didn't know there was one.
It's huge out here.
Hmm.
Because we have all these old people with tons of money.
Yeah, when I worked at the bank, we used to have to do,
You have to do training, right?
Yeah, we had to do training every year, but I used to freeze accounts all the time and do cases to adult social services.
Are you a mandatory reporter, banks, if you see suspicious activity?
Yeah, we are.
Yeah. It's good. Honestly, our old people need protecting. You think, oh, they're fine. They're doing it of their own free will. But you get them alone and they're like, yeah, I feel responsible. I don't know what to do. I'm in it too deep now. She needs money. I have money. You get them alone and you really get them to talk to you. They're victims.
Most of ours were angry.
Yeah.
How dare we? No, how dare we cut off access to their money?
Oh, jeez.
And we're like, we're saving you.
Yeah.
You just bought this lady 5 cars.
Yeah.
But yeah.
Yeah, I will send you all that, Will.
Okay.
I'll just send you my motion, my objection that I just filed because it says this person is an elder based on this probate code. He was a dependent adult based on this probate code, like if they really need help.
Mhm.
He was a dependent adult. My dependent adult is a little bit of a stretch of an argument, but the purpose of me filing this motion was to get a settlement instead of.
Right. That's the thing with our cases, even though it was like $2 million in damage, his only heir, his only daughter gets $500,000 and everything else goes to charity.
Yeah.
So we're probably not gonna push it very hard.
But, well,
You know?
charities are
I
the
know.
most ruthless litigators I've ever dealt with.
Charity?
Well, they want their money.
So have you,
They're tax free
and they
money.
have they have in-house counsel. Have you guys reached out to the charities?
We told the other, well, part of our settlement is a thing we're gonna offer to sell it to the charity. So that's sell the case, I mean,
Oh, sell the case.
yeah.
Yeah. Ooh, I just was shocked. I worked with a charity recently on a house, the house I just told you guys about that they got the old lady to sign the house over. 50% beneficiary of her estate was a charity. And 50% of that estate was $400,000 or $500,000. That charity wanted blood from that caregiver. And it was a Christian charity.
They're worse.
Wanted blood.
Really?
Yes. And they did not care how much they had to pay us to litigate it.
We should contact this charity.
They were like, just get the job done. And we did. And our firm is really efficient as far as Julia's firm. She has it all set up. It's very, very efficient. We get things done in a cost-effective way. It's still super expensive, but we get things done in a cost-effective way for our clients. They had in-house counsel. That's all we talked to was the in-house counsel. And they took this thing right before trial, we settled, which was a really good outcome for our clients. Because they would have paid us, the amount they had to give to the caregiver, they would have paid us for an uncertain result in trial. Because it depends on the judge. Next Monday, I have my first elder abuse case in front of Judge Evans. I'm really interested to see what his position is on it. Like, we knew what Judge Cox's position was on certain issues.
Last thing with Judge Evans is that he will listen to every argument, sometimes whether or not he really should, but he will always hear everyone out, even to like, I love that about him, but some people are annoyed by it. That's the one criticism that I've heard of it.
Were you with him mostly in civil court or probate court?
Only criminal.
Criminal. Oh,
Yeah,
that's
if
right.
he was in criminal,
Yeah.
yeah.
I forgot about his little stint in criminal. Yeah. But we've been really pleased
Mhm.
with practicing.
Well, he's back in civil basically, so he probably is more in his zone.
Yeah. Yeah. Who's this guy up front here?
Son.
Yeah,
He's the new justice.
Oh, he's an adjuster.
well, he's actually,
He's a public defender.
yeah, he's the IT guy for the PD's office.
Fantastic.
Yeah, he's good.
So what is the schedule tonight?
7:30 is break, and then out at 9:30.
Do you guys have to stay till 9:30?
No,
Is there-
that was a rule last year, but it has not been reiterated this year, and everybody left it last night.
On the second night, it hasn't been reiterated yet.
Well, and the thing is though, is that like, even AJ let us out early.
Well,
Yeah, I know.
let me tell you, if you guys were ones or twos, I'd stay here until 9:31. But you guys know what you need to do, and you have the bar breathing down your neck. Like, there's no reason to draw a class if you're not learning things that are going to make you pass the bar. The reason I'm telling you stories is because that is how things clicked for me in different classes. When you see how these rules of wills and trusts actually apply in the real world.
Civil procedure, oh my gosh. Doesn't make sense until you do it.
Yeah.
It doesn't make sense at all until you do it.
Discovery,
And then it's
what?
awesome. And then it's awesome.
You guys all know this
So
stuff.
Peter's
Just get a
awesome.
really good paralegal at it, because I don't want to remember all that crap.
I love civil procedure.
That's what my attorney is.
I hate
She's
it.
like, Marcia, when is this due?
That's right. Calendar it. Just tell me when I need to get it done. Yeah.
When does Abacus say this is due? Okay, good.
We just got we got a new front office person who has 15 years of experience in family, criminal, and civil. And it has made a huge difference. It's awesome. Just give her stuff. Okay. Pay on death, transfer on death contracts. That's C. Pay on death, you can set up pay on death beneficiaries on accounts. That is something that goes outside of probate. So pay on any account you have, pay on death. There's also a small state affidavit, so basically, you know this from working at the bank. If it's under $150,000 and it doesn't have to go through probate, you fill out a small state affidavit. That person is swearing under penalty of perjury, they're the heir, or you can have 2 or 3 people sign. They are the natural heirs of that, and they take responsibility. So if the bank turns the money over to them, they are indemnifying the bank. So then if someone else comes forward and says, no, that money was mine, they're indemnifying the bank in a small state affidavit saying, turn the money over here.
What is the rule in California for small state? Is it
50?
what, 50?
Wait, 50 for real property. No, it's just under 150.
Your bank would only take it if you had less than 5,000 in the account.
See, and every bank has a different rule, and I tell my clients that too. They're like, well, what's the rule? And I'm like, every bank's different. Some banks let you have 2 pay on death beneficiaries. Like, you have 2 kids,
Yeah,
split it between these 2 people. Some banks only let you have 1.
because it's a hassle. Because
Yeah.
you have to give the funds out of the account at the same time. And
Yeah,
we've had
that's
cases
not
where
fair.
you have 1 kid in New York, 1 kid in Florida, and
Yeah.
1 kid in Oregon, and
Yeah,
you're trying to get everything all at once,
Right.
and it's a hassle.
So we did a small state affidavit that only works for the entire state center, like 50K,
under 150.
under 150.
Yeah, small estate FJ, it's a 13101, probably could be 13101. You're saying the entire value of the estate is less than 150,000. But what Vince is saying is that his bank would only accept those if it was under 5,000. So if it was $6,000 bank account, you get a court order.
Yeah.
You're gonna have to pay an attorney $6,000 to get a court order.
The bank just wants to keep it.
What bank is that?
BBVA,
I'm not familiar with their practices.
you're small, that's why.
Yeah. Yeah. And like, if you're an attorney calling a bank, they don't talk to you, nobody talks to you. They don't want to talk to you. Nope.
Well, because we don't know anything. I mean, if a lawyer, but at the same time, our legal department, we can't give out their phone number or anything like that.
I noticed that,
So it's
Yeah.
basically,
because we were trying to get Union Bank to turn over those funds to our clients, and we wrote a really nice letter. We're like, dear legal department, you guys are lawyers. Here's the law. Research it yourself. They're like, nope, court order.
well, and the problem
And they
is,
tried to get my client to pay their attorney's fees for going to court.
no, you want to go on your own.
Yeah, Judge Evans goes, yeah, that's probably not gonna get granted. He said that to
To
the
the
opposing
lawyer.
counsel. Yeah. Yeah, Your Honor, we want to reserve the right to file a fee petition for the, and Judge Evans like, that's probably not gonna get granted.
The problem is that all these banks have branches in different states, but like for our bank, the legal department was in Houston, and they were all Texas attorneys. And so we'd be like, well, what's California law?
Right,
They're not.
I can't practice in California.
And we're like, well, then you're useless to us.
Right, absolutely, jeez. So pay on death, that's for an account. Transfer on death, that, from what I understand, is only you can file a transfer on death deed. I've only filed one because that just became available to us, I think January of either 17 or 18. Transfer on death deed. You just file that against your property. You should give somebody a copy that you're transferring it to. You could have a $4 million house and it could transfer on death to whomever you name as the beneficiary, and you avoid probate. No trust, nothing, you avoid probate because you have left instructions. Basically, you've left instructions with the county saying it goes to this person. And then joint tenancy, it's as we talked. Joint tenancy can be on a bank account. I always associated joint tenancy only with real property. You can have a joint tenancy bank account with your significant other, your spouse, your parent, anyone. When you pass away, the entire value of that account goes to the joint tenant. And you can also do that on homes, but in joint tenancy. But as I mentioned before, the risk in doing that, if you're doing it for reasons because it's your significant other, your husband, your wife, that's fine. Sometimes parents put a child on the bank account so the child can pay all mom and dad's bills. That's a different reason. If you're doing it for estate planning purposes, it's not that great of an idea because you never know when you're going to have a creditor. Car accident. If you're married and your husband gets into trouble and you're the one that's on your mom's account, they can get to it eventually. Depends on how aggressive the creditor is. We've seen some very aggressive creditors. That's joint tenancy. Does anyone have any questions about?
Kind of.
Yes.
So just because I like IP, did I also try to pull that off? Like, where in California you do have the right to
Yeah, you do.
pass on your likeness.
Mm-hmm. Your what can we call
Page
it?
40. Or I guess it starts on page 30.
Yeah, where the basically the right to your
Likeness. You can inherit.
celebrity, basically.
Yeah, property rights, freely transferred.
Yeah, California was successful, but then they determined that Marilyn Monroe wasn't domiciled in California. She's actually domiciled in, I think they said New York.
Yeah, so
And New York,
for her, but
yeah, and New York doesn't grant it as a transferable right.
The amendment was enacted by the wrong state.
Yeah.
Let's try it, but I mean.
Yeah.
But for now,
The Ninth
future
Circuit,
celebrities.
held that Monroe died at domicile in New York, generally speaking. So it depends on what state you were domiciled in to determine whether or not your likeness can be passed on.
California's a very pro actor.
Clearly. Right, what would Hollywood do if California didn't do that, right? Monroe's successors have lobbied the New York legislature to adopt.
I think they did retroactively, so on the road, but it's domicile in the wrong place.
Summed up the status of those persons. We observe that the lengthy dispute over the exploitation of Marilyn Monroe's persona has ended in exactly the way that Monroe herself predicted more than 50 years ago. I know I belong to the public and to the world, not because I was talented or even beautiful, because I never belonged to anything or anyone else.
I have a question. So an intervened trust passes, does not pass through probate, but it says that a testamentary trust created under the decedent's will does pass through probate.
That's because you don't actually have a trust, you have a will.
So this is, but to pour over into a trust is not created under, like, what's there into a testamentary trust? Just a testamentary, yeah.
Where are you at?
Page 42.
Okay. So
Just says
let me
intervened
make
trust.
sure I understand the context. When property is put in trust, the trustee holds it for the benefit of one or more named beneficiaries. So so we go through, let's go through this line by line. When property is put in trust, the trustee holds it for the benefit of one or more named beneficiaries. So let's say, well, you create a trust, you put all your property in trust, you are technically holding that property for the benefit of your beneficiaries someday, right? However, during your life, you're the beneficiary.
Sure, I
Right.
can take out of it.
Right. You can take, the whole trust, it actually says, for the benefit of will, all of, it's you, it's your stuff. You can put stuff in a certain kind of trust where you can't touch it anymore, and it is for other beneficiaries. But property held in trust, in general, trustee holds it for the benefit of one or more named beneficiaries. The trustee distributes the property to the beneficiaries in accordance with the terms of the trust. Okay, so during your lifetime, you are the trustee of your trust, but then you name successor beneficiaries. So when you die, there's a successor beneficiary who's then a successor trustee, which is basically just the new trustee that will distribute to your beneficiaries in accordance with the terms of the trust. Property held in a testamentary trust created under the decedent's will passes through probate, but property in an inter vivos trust during the decedent's life passes in accordance with the terms of the trust, avoiding probate administration. In contemporary practice, the inter vivos trust has displaced, the testamentary trust as the preferred type of trust. So we don't
Yes, I'm doing
know, but you can create a trust in the terms of your will. But what do you have? You have a will, right? Through the probate process, a trust can be created because your will says create a trust, but upon the date of your death, you didn't have your property in trust.
Sure, so it's like in my will, it says, this money is gonna go into trust for my kid
Yes.
to be paid out
Yes.
as he makes the money,
Yes.
it'll get matched or something.
Yes,
That'll be a testamentary trust.
yes.
Okay.
You can, testamentary means I am saying that I want a trust created and I'm writing that in my will. So on the date of your death, there really isn't a trust. There's just a will. So the will has to go through the probate process, and then the executor of your will creates a trust and does whatever you say for it to do. But we just don't do this because the purpose of a trust is to avoid probate. And we do that all the time. We say, here's my trust. I have 4 kids. One has a spending problem, one has a drug problem, one has a deadbeat husband, and the other one's fantastic. So we're gonna give the fantastic one we're gonna just give them their beneficial interest outright and free of trust, meaning they just get it. For my other 3 kids, for the one that has a deadbeat husband, I'm going to set up a separate property trust.
Sold separate.
So it only goes to my daughter, and her husband can't touch it. For my spending problem kid and my drug addict kid, I'm going to hold their money in trust, designate a different trustee to only spend money on them for their benefit, but never give money directly to them. You can create whatever you want.
Awesome.
Whatever you want. You can make it say whatever you want. So that's why when I say like this is just a standard trust, there's so many. I had to do a trust summary yesterday. One trust, depending upon who died first, husband or wife, created 4 different trusts. And so I had to say, here's trust 1, here's the actual trust that you put in front of me. But if this happens, this trust gets created, and here's the elements of that trust. But if this happens, this trust gets created. Here's the trustee of that trust and the beneficiaries of that trust. So if this happens, right? So I basically had to summarize 4 different trusts that were created from what? Because every fact pattern is so different. No one trust, unless you have 1 kid, nobody's just gonna, it's rare for it just to go, yep, just give it all to my kids equally outright and create trust. There's always a situation. And that's our job, to listen to that person, tell us your story, tell us what you want, and let us record that in your document. People are so thrilled when they realize we can create a trust and never give your kid money, but just buy them things. You can buy them a house, you can buy them a car, but it all stays in the name of the trust and they can't touch it. But they get to live in it, they get to drive the car, and they get to have a TV. They just don't get to sell it and use the money.
That's kind of awesome, yeah.
Right? Because then you still get to provide for your kid and not worry about her shopping habit or his drug abuse problem, right?
It can't be used for that, yeah.
Right. Yeah, primarily.
Unless you go sell the car.
Yeah, which you shouldn't be able to do, but yeah, exactly. Okay, so that was a great question. What else? Probate terminology. So right here it says the fiduciary. So You'll name it in your will. Is someone here? Do you guys want to say a word?
You think we should come back and then like do like 15 minutes and then, or it matters.
Or however long it takes, yeah.
Sorry,
Yeah.
I don't wanna.
I'm good with 15 minutes.
Only 15 minutes, that is your.
Sorry, I didn't mean to like.
You guys tell me. All right, take a break.
That way it'll look kosher.
We'll pretend we're being good.
Mm-hmm.
We are good.
Looking hot.
It is.
Yellow drum.
60 in here. Do you remember what the password is for these rooms? I got a new computer, but.
I have no idea.
Yeah, for the past 2 nights, we're waiting for it to kick on and it's just not.
What is that?
You guys are empty. You guys are cooking.
Well, no, this is 78 when we got here. That's just telling us, I think, that.
Because there's lots of activity going on in here.
There it is. Yeah, it just wouldn't kick on. I'm like, what the heck?
This is nice.
Oh, you haven't been here, huh?
I think I saw this from a distance. One day when I hopped in, I think I looked. Yeah, I just can't remember his name. Yeah, it sounds about right. Hi, Keith, how are you?
Good, how are you?
Good, nice to see you. Julia's the main professor, but she's out of town for 2 weeks, so the associates, we are taking turns. Yeah, it's fun.
Nice.
Yeah.
I hope so. I'm just doing what I would like, which is, here's what you need to know. These cases are great, but let's learn why we have estate planning, wills and trusts, and what elements, what issues are at. Wills and trusts is very highly tested.
Well, I probably
So I heard.
What's the trust or carry property?
Yeah.
Which one is more straightforward? What's the easier? Is it?
What is it?
Oh.
But keep in mind, wills and trusts, we can make it harder than it is. It's like civic codes, like, you're like, oh my gosh, right? But when you really, you're like, oh, that's it.
It was so bad for me the whole year, and then I told Veronica at the end, I was like, oh,
Yeah,
okay, it's not so bad.
yeah.
Just while you're doing it, it's like,
It's really confusing until you get it.
are we answering phones right now?
Oh my. Very nervous.
I shouldn't have floated around here. There was 2 parties. They had 2 different parties. Shoot out of the one part, shoot out of the
Real property.
That one, I guess, was here for 2 years. Since he was 16. He's 20. So the whole thing is like, okay, I think we're just trying to kind of, keep the chaos of the parties and jury. That's the goal here because, the case sucks. The DA really does. They have no DA. Nothing. Nobody specifically ever identified.
The last time you saw you in your life, I was afraid.
It seems so like that. Because right, and that's what I'm worried about, that we're just something way much right now. We don't want to share. Or it'll hurt someone
No, that's
not because
every day I saw this he's having a lot of bad days, every now and then he's having a decent day.
So, I don't know that I'll be doing, trials, yeah, during class. And that was actually when I was selected. Oh, wow, how are you? Well, that's
Really, you look amazing.
it was not supposed to be too tight, so it's just.
Really, it's like,
So we ended up not-
when you're walking through their song, it's like, that is so fun.
Contract drafting and, music already.
So he's got really good doctors up in CSF. He's getting, there and Lauren Jones, he's primary oncologist is in Lauren. And then the second she has specialist.
That's where I'm at right now, I kind of have it, I'm planning to start early.
I was taking her
I'm
radiation.
trying to figure out every day, I want to kind of plan this, I get to do it. Really need to write it.
Then my sister-in-law, Richard's sister, is there.
We have it here now, so go get it. Okay. That's fine. Oh, Isabel. Hello. Good to see you. So, yes. That is.
So, are you having fun? So, tell you what you guys put up there.
That's scary. But it's,
Yes. So we have. Yeah, let's get the date. Yes. So whatever it is, midterms are 2 weeks before midterms.
and for me, though, sorry, you know, I try to, but I be honest. Hopefully. He has another scan coming up. This weekend, there's another scan. He has one on Friday, and I'll be back up, I go back tomorrow. I don't remember which one this time. I know he has that before, but I don't know what he's getting this time, I don't know. Oh, well, he has that one. That's how he knew that it had really metastasized, and that's how he knew. Yeah, yeah, he knew that. Yeah. That was the bad news he got last week.
We were looking for the.
I just found
Oh, you did?
I got those.
We actually did need one, thank you.
Well, he doesn't listen to me. I honestly, I'm having to really keep my distance to some extent because he does not want to hear anything I have to say. People are so sweet. Everyone's saying, well, you're going to offer this to Richard. If I can put on my mouth, he's really not interested. And that's what I'm having to hear. I saw you right there in Wills and Trucks.
Oh, now it's pretty nice.
They're not, but I'm just natural.
Yay.
And you know what, I just try not to have that. I have too much.
Someone's gotta use it offensively.
So I'm doing that, just not.
We'll do a scavenger hunt to collect different parts of the riddle.
And I,
What?
We'll do a scavenger hunt, right?
Exactly.
A riddle. That's a riddle.
There was
Oh, that's a
a
treasure. Treasure.
there was a whatchamacallit,
This is whole anime on there. One Piece? Is that what it's all about?
well, there was a white collar episode about that, like where he left two different wills, one to one son, one to another son, and they had to try and like find out things.
That's what he said, it wasn't the same, he didn't have to, but now it's perfect. Yeah.
What's the future? It's gonna be like, well, here's my passwords to all my accounts and all the digital content.
No.
This person gets my Sony account. This person gets my Steam.
This is the good thing. He doesn't know what the language is. Excuse me, now he's finding out.
Do something about it. This video game account showing this person was playing this account to keep it active. Something.
That's a same thing. Well, he works like in 24-hour days working for him. It's like, you know, that is not my experience. But he has to come to that himself. Flying cow is not bad. Oh, that's right, you have to be extra careful. Yeah. So, do you get iron? They can take iron on top of that? This is okay. You don't usually do it. You should have lost a lot of weight. I mean, in the very beginning, he had no appetite, he was so now he's here. Now he's looking on cigarette again, so. He kept his appetite.
You look like the perfect for now, both of you are on the phone.
Because we're learning. It's so much learning. I'm over learning.
It's an overload.
So when you study, this is the last resort, really. And that would be, honestly, well, but I used to use all kinds of things, so that's the last resort. That's why I don't be friends with, I used to, and I know they were.
Hey, do you guys remember the Wi-Fi password? Is it 16? It's a number.
I think it's $2016 sign.
I don't know, unless that's just automatically connects.
It's better.
Doesn't change.
We'll leave the door open, let's get some air. Are you guys still breaking? Are you ready to call?
We're good.
It's a lot cooler in here now.
Yeah.
Well, no, because I got her to get the AC to turn on.
All right, let's finish up chapter 1, we'll breeze through this is like your best friend, examples and explanations, and tells you, really brings things together. This book is great, but It's like reading the tabloids.
I'm so happy.
Reading the cases isn't gonna help you pass the bar, but you have to know the concepts that they talk about. You guys know this. So probate terminology. When you name an executor in your will, or some wills, like this one, didn't name an executor, right? An executor is the person in charge. It's also called a personal representative. They are also a fiduciary. They have a high duty of responsibility to make sure they manage everything appropriately, or you can be held personally responsible. And that's why I mentioned earlier in class, in a trust and in a will. In a trust, it's the successor trustees. In a will, it's an executor and successor executors, or sorry, alternate executors. You want to name 2 or 3 of them, because one person, if they've done it before, says, I don't want to do that. I don't want that responsibility. I don't want to be, I know the kids are going to start arguing, I don't want to do it. So we name alternates. So that's why you name a couple of them. It says if they cannot or choose not to, if they are unable or unwilling to serve as executor or as successor trustee, here's the alternate person. And here's the alternate person after that. The fallback, if everyone says, no, I'm not going to do it, we ask the court to appoint a professional. And there are a handful of people, especially out here in the Valley, that's all they do. That's their professional job, to act as successor trustee of people's trusts or executors of their, we don't really have problems finding people to be executors of wills. People are like, yeah, I'll do it. They don't know what they're doing too. Okay. I want to tell you guys the fun stuff. You know, of course we have things that go smoothly and nobody objects and the family kind of gets along, but it's the fun stories are the ones where it's exciting.
You're saying it's so fun.
Oh, so here's one of the great ones. The guy who left his housekeeper in the house, right? The children are objecting. Here's the biggest point of contention. It says, I leave my house and all the contents. They say, housekeeper says, contents of the house includes the dog. What do you guys say?
Well,
Is the dog in any way otherwise mentioned at all?
Can I see it?
no.
It's
Do the
in
kids
the
have
house.
a relation with the dog?
The kids know the dog because they did visit regularly. They don't know the dog as well as the housekeeper because she was there, it seems, quite often. We don't know for sure, but it seems as though she was there quite often.
I feel like that'd be one of those cases where you put them both across the room and call the dog and see where it goes, right?
It's a great idea. It's a great idea.
Well, Solomon and like,
So,
So
yeah, slap the dog.
tomorrow my job is to research, I talked to another attorney about it, tomorrow my job is to research exactly what does contents of a home mean. There might be case law that says, this is what contents means. But we did research, a dog is personal property.
Chattel, sure.
Oh, yeah.
I mean, that's the case, you know, trespass, if you kick someone's dog, it's trespass to chattel.
Yeah,
it's-
right, great point. So, it is property that he can give away, but whether or not that is included in contents of the home. It's not traditionally thought of, contents of the home is the furnishings, right, the dishes, the knickknacks. It's not usually a dog, but in this case where there's a dispute, so daughter took possession of the dog and says, I'm not giving up the dog. Even if they get the house, I'm not giving up the dog. Housekeeper says, dog is not negotiable. I want the dog. So this is where we're at. It's a St. Bernard. Yeah, it's very. I'm the person who advocated for these dogs to get this 60%. So you can imagine I feel very strongly about this.
Well, there was an episode with Judge Judy on that, right?
yeah.
Well,
I said, okay, tell the dog who you want. Dog, decide.
It was really obvious the dog was all happy jumping towards the plaintiff, right? So, so
I
it's,
love this. I'm gonna suggest that to
There's a Judge Judy episode where they put the dog up by Judge Judy and
Is
they,
Commissioner Reed still teaching here?
Oh, she's not?
I don't- there's an asterisk next to her name on the thing because she was gonna do that, she was gonna go somewhere and take a class or something like
She was
that.
talking about doing something else.
There's an asterisk next to her
Okay.
name. Next to PR. So there's no teacher yet assigned.
So one of the reasons I ask is because I think opposing counsel on that case with me and the housekeeper is her son. But I don't want to ask him.
He's a teacher here.
Who?
Her son.
Her son.
Which one?
Shoot.
I don't know.
Contract
Reed.
Yeah, Reed.
Yeah, he does contracts.
All it says is Reed.
No.
I don't know his name.
I don't remember.
I'm gonna have to ask him tomorrow. Because I don't want to go, oh, is your mom Commissioner Reed? You know what I mean?
Sure.
I don't want to. He might be tired of being under the shadow of Commissioner Reed, so I don't want to ask, but his last name's Reed. That would be very interesting. Okay.
What does he look like? Is he a black dude with a beard?
Yeah,
I'm not sure if he has a beard, but I know she has two sons.
Right.
I think.
Does he both have beards?
Where does
Are
he
they both
work?
attorneys? He's an attorney. I mean,
Yeah.
they're
both
Both
attorneys.
attorneys.
They both attorneys?
Yeah.
One works.
That doesn't help at all.
One works for Tekla, and one works for, I think, Hertzler. Okay, find out. I'm on it. Okay. So probate terminology, the executor is the same thing as the personal representative. If there's no executor named in the will, then you are the administrator. They all mean the person who is going to administer this estate, go get all the assets, bond them together, and distribute them to whomever you think they're supposed to be distributed to. So I'm just making sure we understand. We do not use executrix or administratrix anymore. It's just executor, administrator, testator is the person who wrote the will. Heirs, you guys understand that? Is there any language in here you don't understand? So opening a probate, you fill out judicial counsel forms. I'm making it sound easy, but you really have to know the case to be able to accurately fill all this out. You file it with the court, you get a hearing in about 4 or 6 weeks. If nobody objects, the examiners have the opportunity to look at your petition and say it's missing something or it's good. They say to the judge, we recommend you approve this, or we recommend you continue it because of these reasons. You know exactly what's going on at all times. These probate notes are published. So you get the probate open, and that means that that person, the court has given that person, the executor, administrator, personal representative, all the same person, it gives that person the authority to go out to banks, to sell houses, to go out and start gathering this person, we call it marshaling the assets, to go out and start gathering this person's assets. So at that hearing, the court gives them the authority to do that. They get court documents that they take to the bank and say, I'm now in charge of this person's accounts, give me the money. They can go to a real estate agent and say, I now have authority to sell a house, sell the house, right? So all these things are in somebody else's name. So they have to have these court documents that give them authority. Then we have to file inventories with the court to say, here's what we've collected, here's what we know is out there. We have to provide bank statements, account statements, real estate appraisals. The court really wants to know all the details of this person's estate. For this lady, I had an inventory with a P.B. Herman doll, with choo-choo trains, with antique chests full of old photographs. It went on and on.
Do you decide who gets the Peter Herman doll, who gets the photographs, or does that have to be auction offers?
So it depends on the estate, but typically those things are, so the person who is in charge of the estate, administrator, executor, or personal representative, the person who's in charge of the estate has a duty to maximize the value. We thought the P.B. Herman doll and there were a pussycat doll, there was a doll collection, all still in the boxes. We thought they might have value, so she put them on eBay. Nobody bid. So at that point, they are deemed to have garage sale value. And if any of the remaining beneficiaries want them, they just take them. If they say, no, that's worth $100, you can't just have it, that person might have to pay into the estate some money to take that. So as long as it's fair. But if everybody agrees, this crap's not worth anything, you can just take what you want. This particular case was extremely contentious. One of these 4 beneficiaries was very difficult. I know all 4 of these people extremely well now. One of them was very, very difficult and objected to everything. There's some TV show, so the decedent had a gun that was used on a TV show. Anyways, it was a lot. So we file inventories saying, here's all the inventory. That state had 6 or 8 guns in inventory. Those had to be purchased because we went and got them appraised. Well, we told the administrator, go get these appraised because they probably have some kind of value. You have to file that inventory. You have to, even when everything is settled, you have to file a petition with the court that says, here's what we collected, here's who we think it should go to, and we still want the court to bless it and say, okay, go ahead. Until the judge signs the final order distributing the estate, in many cases, nobody gets anything until that final order. If there's tons of money and everyone's kind of in agreement, you can take a preliminary distribution, but in most cases, you have to wait till the end, the court has to sign it, and then you distribute things, including guns, dolls, cars, homes, cash. It's all part of the estate.
So they kind of put their name on the things they want, essentially.
Yeah. But if everyone's getting along and they're not really any high value, people are just like, oh, just take it. Right? In this case, they sold the house, they bought they rented 2 storage units. The family the 4 beneficiaries had designated times where they came and looked at stuff, all at the same time, so no one took anything from the other one. We had an independent, objective person there, so that if anyone got into a fight, that they would rely on that person to settle the dispute. It gets crazy. Welcome to family law. It'll be fun for you. Okay, so the document that the court gives the person saying you have authority now to administer the estate is called letters of administration. So that is the document that's stamped with a blue stamp that person can then take to each place that the decedent has assets and marshal those assets into the estate. Okay. Supervised and unsupervised, you can ask the court for just limited authority, like that person can go get bank accounts, but they can't sell real property. So there's different types of authority in granting administration. In granting authority to someone who's going to administer the estates, most cases, full authority, no rules, go do whatever you need to do. But if there's any question as to whether or not that person should be able to take possession of certain things, you can give them limited authority. You have to give notice to creditors. Hey, we got this person passed. We have assets here. We think you might be a creditor. You have a certain number of days to file a creditor's claim. Then the person in charge of the estate can pay it or reject it. If they reject it, they have to go file a suit against you in civil court. So there's a process to that. Does that all make sense? Any questions there?
How would the creditors would just have to show an invoice to say, I didn't get paid this?
Yeah. Outstanding credit card bill. Most of the time, credit cards, in my experience, don't file creditor's claims. Or if they do and they're rejected, they don't file a civil suit. We just had one where about $14,000 of debt went away because the administrator rejected it and the creditor didn't file within 60 days. I think it's 60 days. They had to file in civil and they didn't. So it goes away. It's done. The other trick, I'll tell you one fun trick and then we'll wrap up. Any creditor, even a spouse that is owed alimony, any creditor has 1 year to file. So if Nancy passes away and Nancy owes ex-husband, spousal support, Nancy owes, I'll just give you a true example of what happened. It's the same Union Bank case. This lady owed a car dealer, car got wrecked before this lady passed away. The car was not paid for. Lady owed car loan place over $90,000. It was a nice car, completely totaled. It went over Highway 74, if anyone knows that case.
Oh.
So the Porsche got totaled. It was in, decedent wasn't driving it. Somebody else was driving it. Insurance said, we're not covering that because you weren't driving it. So now Porsche wants money from her. She does. We waited a year before we opened up her probate, and now there are no creditors. Porsche or any creditor has the right to open up a probate for that person if they want the money. They don't open up a probate, that you don't owe the money anymore.
So you just send a notice of death and then wait a year to
Don't send notice of death. It is up to a creditor to find out
that
you're
they're
dead.
dead?
Because guess what? If you stop paying your bill for a month, 2 months, 3 months, you should probably look into whether or not that person is still alive.
Sure.
You would still have another 9 months to file a probate, and if you don't, you're out of luck.
So basically just hold off on the estate for a year and
If there are substantial creditors, that is
a way around it.
it is a completely legal way to, if there are any assets, to get them to the heirs at law rather than to creditors.
What if a creditor opens up a probate, is it out of their hands?
If the creditor opens up a probate, it's open and they're gonna get paid if there's assets. But then what we do is say, we understand you creditor opening up this probate. Our client, the heir at law, is in a better position to administer the estate. We understand that you've opened this, but let our client administer it and file your creditor's claim, because then you're fine. But it's better for somebody who knows the person who passed to open up the probate, to sell the house, to sell the other cars, right?
Yeah.
What does a creditor know about that stuff? They just open it, not so that they can be the administrator. They open it because they're like, you better do something because we're getting paid.
So would it be like that they hand off the case on to
Yeah. We just did that as a creditor. We just opened up a probate, and the guy who should be the executor was like, you're not gonna do that. And we're like, we don't want it. You can have it, but our probate's open now, so we're gonna file a claim. Yeah, so, yeah. Creditors, no matter what, you have 1 year from date of death to file your claim. Open a probate or file a claim in an existing probate. But if you lay low for a year and nobody does anything, that is gone. 366 point, it's a civil code. That's one interesting thing about probate is like you do civil codes of procedure, family law codes, and probate codes. I think it's 366.3, which is 1 year date of death. Okay. Always get an engagement letter. Right, that's it for the book. Do you guys have any questions in here? I don't want to deprive you of any fun case law stuff. I'd just rather you guys know the concepts rather than the details of the case and understand how to apply them. What is this, 1 through 36? This book?
Yeah. And the first 11 pages are all
Nothing?
I think they're definitions.
Oh,
Yeah,
rehash
mission
of the record.
states, So a will is the document that you have. A codicil is an amendment to a will. You are saying, I'm gonna change my will. I don't wanna redraft a new will. A codicil is just basically a change to your will that becomes part of your will.
How do you spell console?
Codicil, C-O-D-I-C-I-L.
So you just like staple it, or is there
Yeah.
a process?
No. And if you draft a codicil and then you never put it with your will, someone doesn't even know it exists, it's not going to go through the process. So it's important, I always advise to go to estate planning people so that they have a full, every document that you have created. People have amended trusts, but then didn't put the amendment with the trust. Guy dies, kid brings in the trust and is like, here's what you do. If no one knows that amendment exists, we're gonna go off the original document. But then later, maybe someone's gonna come up with with an amendment or a different,
What if somebody finds it after the fact?
it depends.
So if, I mean, everything's gone, then you're kind of screwed.
You're kind of screwed.
But I mean, as far as like 6 months down the line, everybody's about to get paid out.
If
and they
it's a
find-
trust, you have 120 days to go
Oh.
to go find all this stuff. We send people notice that said that all the interested parties.
And you only have to let those you know about know, right?
Yes.
I think I read that in the book, like for, and at least it said for creditors.
Mhm.
You only have to let the ones that you reasonably believe
We are,
creditors know.
there's a mandate, we have to notify Department of Health Services, because oftentimes right before someone passes away, they're provided services from Department of Health Services. So there could be a bill. And we have to notify the FTE. We do franchise tax board. We do not have to notify the IRS unless you know the IRS is owed. But I mean, do you know what your parents, what bills they have? You can't possibly notify every creditor on earth. You check the mail, and it even says on here, I checked the mail for 30 days. I went through, their documents located in their house. You have to check the boxes of what you did to reasonably ascertain what that person's bills are. So you have to make a good faith effort to find out who the creditors are. But if you don't know someone, you don't know to send them notice. Yeah, so you can't be responsible for sending everyone under the sun notice.
And then as far as like letting beneficiaries know, I mean, if you're smart enough to know like the chain,
Mm-hmm.
do you only have to let those know who would be benefiting in that chain? Or like, do you have to let your second cousins know, hey,
Nope.
your
You do not
your
give,
great aunt died or
No.
something like that?
you do not give people notice that are not, so that's one of the reasons, like in our trusts, we say, or in our wills, we say, here are my kids.
Mhm.
So the
That's what you
kids
want to know.
it's only the people named in the documents.
Oh.
So in your will, if we're just probating a will, we're just gonna give notice to everyone that's mentioned in there. Even if like an executor, this executor, the first named executor says, yes, I'll do it. But there's 2 alternate executors, you still have to give them notice because they're named in the document. But if it's a third cousin, just because you're related by law, there's absolutely no duty to notify those people. If you have a trust and then you amend and you say, I'm giving everything to Vince, then you amend your trust and say, I'm giving everything to Will. You have to give Vince notice and Will notice, right?
And then I killed you.
If you, that's right. But if you restate your trust, meaning forget everything I said before, I'm just restating it, you only have to give people a restatement notice. So there's rules to that, but
I'm surprised I have to give anybody notice. Why can't I just have a will that, that has, well, I'll give my lawyer notice of here you go, here's my will. Like, why do I have to tell people what they're gonna get?
once you're dead,
Okay, you mean just, okay,
Oh, no,
sorry.
you're
Yeah, no, it's when you're dead.
Yeah,
you do
sorry.
not give, and I always advise my clients, do not give anyone a copy of your trust because they start counting their pennies before you're dead. They really do. Old people come in shortly before they pass and start giving things to other people because their children know what they're getting and start relying on it and counting it up before they pass. And the old guy's like, give it all to charity. Give it all to Eisenhower. Give it all to Living Desert. Because it makes them feel terrible about their relationship with their children because they just, at some point, children look at parents as, what am I getting from you? It's part of life. And
Usually nothing.
it doesn't make people happy. So you don't give anyone a copy until you pass.
And you have to give notice to everybody that's mentioned?
Yes.
Okay.
Yes. So we always advise, if someone is of the age where we can just completely restate their trust, which means basically doing a new one.
And the attorney has to give notice, or can the executor give notice?
Well,
It's,
for a trust, it's a trustee, it's a successor trustee, and for a will, it's the executor. They're the ones who give notice, but they hire us to do it.
Okay.
So we're the attorney for the executor
Sure.
or for the successor trustee, because you have to send out a 16061.7 letter. That letter has certain requirements. As an executor, you want to figure that crap out? No, you just hire an attorney. We get paid from the trust assets, so that it does deplete what goes to the beneficiaries, but usually that person is a fiduciary. They have a responsibility and they can be held personally liable if they do something wrong. They're usually happy to have an attorney cross all the T's and dot all the I's to make sure they're in compliance with trust administration. That's what we call when someone passes away, and then a successor trustee hires us to make sure they account for all the assets and distribute them to all the beneficiaries. We call that trust administration. And when it's a will, we call it probate. Okay, does that answer your question?
Mhm.
Okay. And that was your original question?
I have another question.
Yes.
It's probably not along the lines of this. So I think I went to a probate seminar a while ago, but they said they asked a question, but she didn't really get an answer.
Mm-hmm.
She was she was an older lady. She wanted to leave everything to her son,
Mm-hmm.
but her son was like an adult person, but he had he was an adult person, but he had like government benefits like Medicare.
Yeah.
So he was low income. But
Yeah. And if you leave them so much money, then they don't
Yeah,
qualify for their benefits
exactly.
anymore, right? Because in order to qualify for benefits, you have to say,
There's zero money.
you have to have no money, right?
Yeah.
That's why you're getting a benefit. So that's when we set up trusts for that person.
Maybe a trust.
Right, and in that situation, we set up we would traditionally set up what's called a HEMS trust, HEMS, Health, Education, Maintenance, and Support. So that's what I was talking about earlier. If you have a kid that has a substance abuse problem or a kid that has a shopping problem, you set up a trust for them. So that is never their asset. They cannot touch it. They cannot control it. But there's a trustee, it's usually another trusted family member, that can buy things for their benefit. But when they buy a house, it's in the name of the trust. When they buy a car, it's in the name of the trust. So that child with benefits is driving a Ferrari, but it's not in his name,
Yeah.
right?
Okay, so
And
but you
so
would
he
need
still qualifies for his benefits.
you would need an executor you trust to be able to do that stuff.
Yeah, you set up a trust and then you have a trustee of the trust, which again, could be a professional fiduciary. If you wanted like
So you can hire people to be it.
there's people that's all they do.
Oh,
You can hire someone to be the trustee and they just have to follow the instructions of the trust. And usually it says, in the trustee's discretion, you can buy things for the benefit of my son.
Mhm.
And that trustee just has to be able to say yes to the television, no to the,
To the meth.
right,
Math and geography.
No meth, yes TV.
yes, that's not to your benefit. Or, if the guy wanted to skip the country, go on an all expense paid trip for a month, but the trustee felt like that was in order to, indulge in his drug habit, the trustee can just stay home.
What was the S? Health, education, medical,
Maintenance,
maintenance, and
support. So basically, those 4 words cover anything you could possibly think of for that person. I had people cut out one of the letters, health, education, period. And the checks will go from the trust directly to the educational facility or directly to a medical facility, and that's it. If it's not helping them with dental, and you right, so if it's not going to a doctor, right, but it's that person's money,
I
then,
know.
yeah. I say just let people have it. Don't control your money after you're dead. Let them go for it. Yes, that's my philosophy.
12 old ladies at the bank were like, I'm spending it while I'm alive.
Yeah, that's
And
right.
I'm like, all right.
Yeah.
She's like, I bought them everything I want to buy them, and
Yeah.
it's my money.
That's right.
That's why you go for your reverse mortgage, you cash out your life.
Yeah, exactly.
insurance,
That's right.
buy your RV and travel the world.
I always encourage people to do that. What are you saving for, right?
It's your money.
yeah, I mean, you don't want to go broke before you die, but
That's
obviously,
the
like,
concern,
yeah.
right? A lot of people are
Oh, yeah.
super thrifty.
you don't know how long you're gonna live.
That's right.
I mean,
I have an 83-year-old that's worth $4 million, and she thinks she's gonna run out any day.
that's why.
Any day now.
But I have
Let
a
me go be
90,
your grandson.
I have a 91-year-old client I'm signing tomorrow. His amendment to his trust. 91 years old. So what if you live to be 91? right? You do have to plan for that these days. You do have to plan for
I
that.
feel later if people at Walmart.
That's right. There's some comedian that always says when he walks in Walmart and he sees those readers, it's like, lucky bastard. Right? Because that's what he gets to do all day. Okay, so administration is the process, it's what we've been talking about. Process of collecting and managing all the property and paying the creditors and getting it to the beneficiaries. Administrator is the person who administrates the estate. Executor is someone that's in charge of the will, which is also a personal representative. And if it's just a will, it's gonna go through probate. Non-probate assets is what we talked about. How do you get an asset to transfer outside of probate so that they don't have to go through probate, right? Pay on death, transfer on death. Probate code, we don't use the Uniform Trust Code, so it's just the Uniform Probate Code. One of the things I think is interesting, I'm thinking on you with family law, but one
I
of the
hated
things,
that whole example.
I think one of the things I think is super interesting is that husband and wives don't understand the concept of separate property. So when a husband or wife passes and there's an account with mom's inheritance in it, let's say wife passes, but she kept her inheritance from her mom in a separate account, husband thinks it's his now. I know, people don't understand that. Here's another one. You know, there's multiple marriages these days. It's uncommon to be in your 50s and still be on your first marriage. So let's say you're in your 50s and you get married for the second or third time. House is probably in one or the other's name. So right, they move in together, then they get married, they automatically think that that's now 50-50. House is just in husband's name. Husband dies. Wife's been living in this house for 10, 15 years and is like, this is my house. Your husband bought it before you were married.
Oh, yeah.
And even though you got married, that didn't give you, he never put you on title, right? You get a portion of the equity that is accrued during your marriage, but this isn't your house. If he has kids, it's gonna get, right?
So be nice to your stepkids.
There's so many reasons why you should go to an estate planning attorney just to look at your overall,
I wanna send my
Life.
sister to you.
right?
No, she has a bunch of like, serious questions about like,
Yeah.
she owns a home and the guy she might marry like owns nothing.
Yeah.
Like, you know,
She needs to protect herself
Like,
because
she
if
just-
something
You ain't no
doesn't work-
punk.
I mean, it's
Oh,
not, she
you're
doesn't
wrong.
like want to like make it weird, but she would like to
You don't even,
tie, you know, like just,
I
that's
mean,
my trust, that's my Caitlin trust.
if
you
she's
know?
a,
Like, the house is in the Caitlin trust. Like,
I'm drafting
No
right
big deal,
now,
you know?
a separate property trust for a woman.
like,
They're already married, but she's receiving an inheritance from her family. And she wants it in a separate property trust so that she can control her husband basically, but I'm not saying that to her. But she wants it in a separate property trust. She's married, but we can do that. We can set up a separate property trust for her to hold her inheritance so that when she dies, his kids don't get it. He doesn't get it, which would ultimately result in his kids getting it. And, or if they get divorced, if it's been in a separate property trust, which is so much cleaner that is her sole and separate property, it is not gonna be eligible for division during the
sure,
divorce.
if he F's off, he can F off, you
Right.
know? Like,
Right,
yeah.
Does the husband have to consent to that or?
Nope.
It's not his money.
not his to begin with. And we're just, as she's receiving this inheritance, she opened up a separate account to receive the inheritance. Now we are immediately setting up a trust to hold it, so it never got commingled. So he has it.
It's great.
If he finds an attorney, he can still sue her if they get divorced for part of it, but it is very, very, very unlikely that unless the judge is asleep, which we've experienced in family law, it's unlikely that he'll ever get into that. So we had a family law case where husband's married to wife A. Wife A leaves. Oh, and he has a kid. Wife A leaves him. He goes and marries wife B, has another kid. in his 40s dies. Family law judge says wife B has to pay for child support for kid from wife A.
But it's not her kid.
No. So $40,000 later, because we hired the best expert in the state of California, like,
She still has to
no,
Oh.
educated a judge,
No.
and now she no longer has to, she didn't ever have to pay. It was,
Yeah.
we got him to change his mind before there was an order, but yeah, $40,000 later, we got the judge to realize, Julia did, I say we, I was just hanging out watching, but, those are unfortunate events because your clients pay for it. But we got Bruce Ross, who wrote the Ross Guide. Yeah, so we're like, this is too big of an issue for,
Yeah.
the kid was 8 or something. It was 10 years of child support, it was a lot. So anyways. So sometimes estate planning crosses over with family law. We hired a family law attorney to co-counsel on that because we are not going to. I will also recommend to all you guys, don't do anything that is outside your scope of what you practice. I think it is really rubbing up against ethics to take on a client for a case that you are not well versed in that area of law. When we will help our estate planning clients do certain things like negotiate a settlement of something or write a contract for something, but in general, I'm not gonna go criminal law and start arguing for somebody. It's not what I do. And I don't think that I've seen too many lawyers get bad results for their clients because I think they shouldn't be doing what they're doing. Okay, do any of you guys have questions on page 9? Even inter vivos transfers.
Well, that's when you do it during your lifetime, right?
Yes,
I mean,
but
basically, it's just,
it is. And I think it's up to $14,000 of cash that you can give someone without filing a gift tax return. And if you gifted someone a property, that is a taxable event. You are giving something to that person during their lifetime. If this person paid $50,000 for a house and then gifts it to their child right before they die, and it's worth, let's just use easy math, $100,000. That person is going, the child.
you tax them $50,000.
If they sell it right then, yep. If you wait, if it's still in your parents' name upon your parents passing away, you get a step up to that $100,000. And now it's a step up in basis. So then Julia will be so impressed if you guys understand step up in basis when she comes
Step
up.
up in basis?
Yes. So the basis is the amount you paid for your house. If you buy a house for $50,000 and then when you die, it's worth $100,000, you now get to claim a basis as if it's a purchase price of $100,000. If you sell it, you got to pay the gains on 50 to 100. But if you die, they look at it as if you bought it for 100 and you're selling it for 100. You get a step up in the basis of the basis is the amount you pay for that property. So there's many reasons why you shouldn't gift huge things during a lifetime.
And does California count it as I know some states covered it, but as part of your inheritance? Does California count it as a part of your inheritance? Or does it have to be specifically written into the will that this is this gift was a share?
Yeah, so to be honest, I'm not sure how it ends up on that side. So right now, as I mentioned, a person's estate before it becomes taxable right now is 11.18 million.
Mm-hmm.
So unless you have more than 11.18 million, you are not going to be taxed on your beneficiaries receiving your estate.
Mm-hmm.
But if you give gifts during your lifetime, it counts towards that 11.18. So you can't give away $10 million the day before you die, and then when you die, you were only worth 10 million, right? And so you don't have to pay estate tax. It doesn't work that way. That 10 million plus 10 million is 20 million, and you'll pay estate tax on $9 million. So it does count towards the decedent's
net worth.
Right. even if you're giving it away during your lifetime.
But now you're in a share of.
But I'm not sure about the beneficiary side. Yeah, it's
Because I know at common law.
I do think it's counted towards your inheritance. Yeah.
I know at common law it said that it was. At common law it was if you were given a gift, you had to physically prove that it was not part of your inheritance because they wanted everybody to get equal shares. And then it said that as time went on, most, I think it said like almost 48 states or so, or it was either 30 or 40 states had switched it to where if it's given to you during the life,
it's not counted
as a share of
because
your
basically
inheritance.
they're saying if there's 3 kids and upon the last to die of mom and dad, upon the last to die, my kids get our estate all in equal shares. The siblings are saying, but you got a house 5 years ago.
Yeah.
That counts towards your share. And that kid's saying, no, it doesn't. I get the house plus a third of mom and dad's estate. So I don't know how it works from that side of it. I'll ask Julia.
Okay.
She'll know that off the top of her head. I've only done this side of it where you say to the person planning, if you give away anything during your lifetime, it counts towards. But I've never done the other side of it, so that's a great question. This is fun. Learn new stuff. Okay. So does page 9 make sense? So I want you guys to understand the big picture of what the purpose of estate planning is. Because I feel like if you really understand it, you can just write the exam on the board. Okay, let me just see if I can get any notes for myself in here. Like Indian land.
Oh, it's all around.
We give that to somebody who does Indian land, right? Like a Joe Roman. Did you guys have Joe Roman?
No.
Okay, he does. That's
We
what
had
he
Mr.
does.
McKee, or yeah, Mr.
Okay,
McKee or something like that.
that's what he does. So we give it. You have to do what's best for your client. So we give that to somebody who does what they do best. We have a paralegal in the Palm Springs office that actually does. She knows she can do the deeds to the land. She can draft. If you're putting
Indian land?
If you're putting Indian, if you're transferring Indian land, she's very good at that. But like if somebody's selling it or there's all these rules, you just don't want to mess up.
Yeah.
Okay.